Yes, there are limits on what on your immunity as a person, but the question is how close are we getting to those limits? Now, in terms of how to reason about an ethical question, one of the classical ethical principles that you use by a process is to generalize. Kant said you should universalize. Well, you can't. That's not possible, really. But you can generalize. One way you generalize within your competence as a lawyer is to use analogies. So you use these analogies that I just mentioned, in criminal procedure, emergency law, and so on. And you see that they are a package that accommodates factors of the immediacy, the clarity, the importance of the threat on the one hand, and on the other hand, the importance of the values that are associated with the victim's personhood, whether there are alternatives that are available to the government that would be less harmful to these values of the individual, or whether there are time and scope limits on what you are doing to the individual, and whether the actor, the person doing the interrogation or whatever, is adequate, or making the decision, is adequately informed about the pros and cons at a level of responsibility that he or she can act on. So some low-level guy knowing about the pros and cons is not good enough. You need a higher level actor for that. Another kind of generalizing is to, by way of analogy, is to look at the institutions that we create, trusts and so on. And those institutions that lawyers create are designed generally, I'm just having to do this quickly, but I think you get the idea, for transparency, for susceptibility to audit. We tend to think of institutions that, governmental institutions as requiring consultation. See, those things could be built into a system of interrogation. And so you could use those in your advice. Lawyers, I think, are peculiarly good at perspective, or they ought to be, about legal history. If you look at the Japanese relocation cases and the Communist Party cases of mass hysteria, very similar to after 2/11, history shows that draconian methods were just simply not justified at all. The lawyer needs to bring that to bear in the advice. And then you need to consult widely in your advice. That's a way of generalizing. And unilateralism was, of course, one of the basic problems of the whole Bush administration. And finally, you've got to exclude self-interest from your advice. And that means when you're working for people at the very top, you have to be willing to stand up to them rather than to pander to them. And that's not easy to do, but it's part of the job. You can't over-identify with your client politically, just like in Enron, the lawyers over-identified with their client. Deborah's written about that. Over-identify with their clients economically. Well, they couldn't give objective advice as a result. So with these reasons for ethics and the processes I just mentioned, what would ethically constrained advice look like? Well, you would fully face up to the values of personhood. You would flag the moral and legal risks that the client might be running in radically departing from established law. You would lay out the options so that the president could act responsibly. You would stress the emergency limits, the limits in emergency law. And you would note, by the way, and I'd like you to note, that emergency law, like self-defense and so on, it takes account of the danger to begin with. So you can't say, well, we got to water self-defense down in order to take account of the emergency. That's built into self-defense. And so you've got to be aware of how far you're departing from that. You have to suggest institutional safeguards. I think they should have set up accountability procedures, pre-screening procedures, consultation of one sort or another. Use the cautionary history. And then I might just add what Brandeis said. He said, I don't know where the line is, but I can tell you when you're getting close. And so the more important it is, the larger margin of error you have to, margin of safety you've got to allow, or at least recommend. Now, you have to be able to do what the client, you have to be able to give the client advice. So he wants to know, what can I do? It's fair to give him the advice. I'm not saying you can't do that, but you can't just do that. And you can't just write an advocacy piece for it. At this level, you've got to include the constraints, no matter how much the client doesn't want to hear you've got to say, you have to know this. So I'm sympathetic to some degree to the OLC feeling under pressure that they had to produce advice fast and so on. But they didn't do any of the above. And it's just totally unacceptable. Go ahead, Linda, you can have my extra minute.
Thank you, Dr. Cole. Our next speaker is Linda Lai, a staff attorney for the American Civil Liberties Union in Northern California. Previously, she had served on the ACLU Board of Directors and its legal committee. Formerly, she was a partner at Offshore Breezen of San Francisco law firm specializing in labor and employment law, as well as constitutional, civil rights, and environmental law. Graduate of UC Berkeley Law, she clerked with Judge Guido Calabrese of the U.S. Court of Appeals, Second Circuit, and for Justice Ruth Bader Ginsburg of the United States Supreme Court. Please welcome Linda Lai.
Bob left off by talking about lawyers and accountability, and that's going to be the focus of my discussion today. As lawyers, we have a critical function, and that is we are in a position to facilitate efforts to hold perpetrators of torture accountable. The ACLU has been at the forefront of those efforts. However, we have encountered a major barrier, several major barriers. Major barrier to holding perpetrators accountable has been secrecy. And this is manifested in at least two different ways. As a threshold matter, secrecy has posed huge barriers to even getting access to the information, the who, what, where, when, how, and why of the torture. All of these photographs, these revelations that Phil showed earlier today, all of the revelations about the torture memos, these were obtained after extremely hard-fought litigation against the government, which did not want to produce the records under the Freedom of Information Act. But fortunately, the courts, in that case at least, did the right thing, and a lot of the records were revealed. Certainly, there may be many more records out there, so that is an ongoing issue. The second major barrier, which is the focus of what I'll be talking about principally today, is once you get the information, what do you do with it? The huge barrier has been getting the courts to adjudicate the issues. And we've seen this over and over in the defense that the government has invoked both under the Bush and Obama administrations, known as the state secrets doctrine. I'd like to talk about a particular case which came out of the Ninth Circuit. The ACLU, the National ACLU in our New York office, and also my affiliate, the Northern California office, brought this case. It went through the Ninth Circuit. It had a somewhat tortured, sorry, that was unintentional, procedural history. It is actually, a cert petition is pending in the Supreme Court now. The case is Muhammad v. Jefferson Data Plan, and it was a torture case. It is a torture case. And it was based on extensive evidence available in the public domain, in press accounts, in NGO reports, in statements of officials, press secretaries, White House press secretaries, statements by Condoleezza Rice. And the case involved victims of the extraordinary rendition plan. I find a lot of this terminology somewhat Orwellian. Extraordinary rendition, it's not really extraordinary if you're a victim of it, and you are rendered. People were transported from country to country and tortured elsewhere at the behest of our country, of our government.